You have been listening to testimony on day 8 of the trial of Derek Chauvin. This has been sort of an interesting morning today where you've had, for the most part of the beginning of this testimony on this day, both lawyers, the prosecution and the defense attorney, interrogating, questioning an Los Angeles Police Department police officer who is there to, in his own personal capacity, to talk about what is effective use of force and what is not. There's a lot of sound bites that we can play for you, so let's get straight to it. Let's start out with the first one that we have, and we'll talk about it.
Can you please explain to the jury what this shows relevant to your analysis?
Relevant to my analysis, it shows when the officers initially removed Mr. Floyd from the vehicle and they placed him in the prone position and they were utilizing body weight to control him as he was handcuffed.
And focusing on this individual, is that the defendant?
Yes, sir.
Right. And are you able to then make out the relative position of his legs relative to Mr. Floyd in that photo?
Yes, it appears that his knees are in a position where he's utilizing body weight, his left knee being in the neck area of Mr. Floyd and his right knee being in the back area.
All right, let's bring in CBS News legal analyst Rikki Klieman. She's joining me now to talk about what we just heard. Rikki, I played that soundbite there to set up exactly what Sergeant Jody Stiger is there to do, to explain the relevance of what we've all witnessed on that videotape, which is, of course, the interaction between Derek Chauvin and George Floyd. And one of the things throughout his testimony that Sergeant Stiger has said is, one, he doesn't perceive, based on the video evidence, he doesn't perceive the bystanders that are watching and filming Derek Chauvin and George Floyd to be threats, which I think is important. And also, as a use of force expert with the LAPD, he says that police officers oftentimes can take other measures in dealing with suspects, including George Floyd, which right before we went to break there, you saw Eric Nelson sort of deconstructing and pointing out a number of instances where, yeah, it's a good thing to talk to a suspect if that's something that can be done. But, for example, would you agree, Sergeant Stiger, that even if a suspect is handcuffed, that he still poses a threat to a police officer? And Sergeant Stiger testified, yes, he does.
What you have here in this expert witness, as I had spoken to you earlier, Vlad, you've got the LAPD use of force division, if not the best, one of the best in the country, for looking back and doing after-action reports to decide if something is excessive or not. You have a witness who has certainly worked thousands of cases, as he testified, but those are LAPD cases, and the but has to do with the fact that it was a bit shocking to hear that this key expert has never testified in a court of law before. That is something that is also not lost on the jury, and it is something that Eric Nelson will eventually argue.
Wait, Rikki, can I ask you about the relevance of that? Because I did notice that he asked him those questions, and explain how significant that is, given that he presumably has worked all these other cases.
Well, I assume that there are going to be other experts in this case, whether they happen to be medical experts in the prosecution's case or medical or use of force experts in the defense case. And one of the things that we learn about expert witnesses in court, they have to be qualified in order to be able to give an opinion. And one of the things that makes them qualified is how many times they have testified in a court of law. We're used to seeing trials, those of us who follow trials, where people have testified not dozens of times, some of them have testified hundreds of times in a court of law. So although he has done all of this work at the LAPD, which, as you know, from my opinion, is about as good as it gets when it comes to this, nevertheless, he has never testified in a court of law before. So if it turns out that the defense has, and I have no idea if they have any, if they have an expert who has testified dozens or hundreds of times, Then we learn if they testified for the prosecution, or they testified for the defense, or they testified for both. We will have a very different weight, if we're jurors, about whose opinion to believe. So it is a very significant factor. One of the things that a jury does when they assess experts against experts, if the defense has experts, remember they have no burden of proof, but if they do, then which one do we believe, or do they cancel each other out? So how many times someone has testified in court is highly relevant. Nevertheless, as you just note, he has assessed, at least for the LAPD, thousands of cases. He presents very, very well, both during direct and cross. But I will say this, Vlad, from a trial advocacy point of view, because I look at that as well as I look at the story of the terrible death of George Floyd, but from a trial advocacy point of view, this is probably Eric Nelson's best cross-examination by a mile.
Let's play, I want to play soundbite number 8 because it goes to what we were just talking about with regards to, or number 7, I should say. It goes to what the defense counsel there, Eric Nelson, is questioning Sergeant Stiger about when it comes to his assessment in the use of reasonable force.
It's fair to say that one of the things that an officer has to do in the assessment of the reasonableness of his use of force is take into consideration what the suspect is saying and how he's acting.
Yes, 100%.
Right? So if somebody is saying, I can't breathe, and they're passing out and they're not resisting, that's one form of an analysis, right?
Yes.
Because the actions of the suspect are consistent with the verbal utterances he's making, right?
Yes.
Other times, and in this particular case, when Mr. Floyd was initially saying that he couldn't breathe, he was actively resisting arrest.
Initially, when he was in the backseat of the vehicle, yes.
Right. And in fact, he was using his legs to push back and to use his body weight to against the officers, right?
Yes.
And at one point, 3 Minneapolis police officers were attempting to get him into the backseat of the squad car from the passenger side of the car, correct?
Correct.
And they were not able to do so.
No.
So, Rikki, you and I were communicating while we were watching this. You know, I find this sort of interesting because yesterday you had Minneapolis police officer Nicole McKenzie, who was questioned by the prosecution. You heard Eric Nelson asking Sergeant Stiger about this notion, and I'm going to reread just so our viewers can understand where I'm going with this. The defense counsel says, so if somebody is saying breathe and they are passing out and not resisting, that is one form of analysis because the actions are consistent with the verbal utterances he is making. In other words, he says, I can't breathe, and he passes out, then that's an indication that he really could not breathe. But then it leads me to believe that what he's trying to suggest is that if you're a suspect and you say, I can't breathe, but you're talking, then a police officer is perhaps right to discount what you're saying because you might be trying to play him, you might be trying to not go to jail, right? But Nicole McKenzie, Minneapolis police officer Nicole McKenzie yesterday was asked about that. She was asked by prosecutor Steve Schleicher that if a person can talk, that means that they can't breathe. And she was there to talk about the training that officers receive on use of force. So he asked her, if a person can talk, that means that they can breathe. No, sir, McKenzie replied. Why not? She goes on to say, that would be incomplete to say because there is a possibility somebody could be in respiratory distress and still be able to verbalize it. Just because they are speaking does not mean they are breathing adequately. And it's interesting to me because you've heard police officers, I've seen videotapes of cops talking to suspects when they say, I can't breathe, saying, well, you're talking, you're doing a lot of talking. And in fact, you hear some of that on the George Floyd tape, where another police officer says, well, you're doing a lot of awful talk, you're doing a lot of talking for somebody who can't breathe. Is that something that the jury, I mean, if you're a juror, how would you interpret both of those analyses?
Well, you have to look at also what other experts may say, and that has to do with medical experts. It is often thought of, for example, amongst lay people, that if you're starting to choke, and you're gasping for air, that the person across from you says, try to talk. And if you can talk, the assumption amongst lay people is, of course, if you can talk, you're okay. You're okay. So just as police officers are dealing with people who may or may not be resisting arrest, people who may or may not be in distress, if someone continues to talk to you, the reasonable police officer may decide, based on his or her experience, that if the person is conversing with me, that obviously they are not in distress. Now, a medical expert may say that they are in distress because they are not getting enough air adequately, to use your phrase, not adequately. But what is the reasonable police officer supposed to do? That is the ultimate question here. When the jury decides whether or not the force that Derek Chauvin used on George Floyd while George Floyd was speaking was reasonable. I'm not talking yet about the force that was used after George Floyd stopped speaking. But what Derek Chauvin did, according to his defense lawyer, through these questions in cross-examination, what Eric Nelson, the lawyer, is trying to show is that this is a constant assess and reassess. Look at the factors around you, consider them, reassess the amount of force that you're using, and that becomes intuitive as a result of your training and experience. I've mentioned before that this also all sets a possible stage of Derek Chauvin deciding to take the witness stand in his own defense. Of course, it is his decision and only his. But I would not be surprised if he does decide to testify and say, look, I've been a police officer 19 years. I have done this exact same maneuver. I believed that it was in my training because I've seen a photograph, let alone experience, of someone putting their knee on someone's shoulder, and that is where I thought my knee was, and that none of the people that I've arrested in the past, even when they said they couldn't breathe, had any adverse results. The only person who can testify to that, based upon Derek Chauvin's own personal experience, is Derek Chauvin. There's no other way to get that into evidence. The only other decision that the defense would have to make if Mr. Chauvin decides not to testify is they need their own experts, and continuing to cross-examine these experts, to show that someone who says they can't breathe, especially as early in this encounter as the tussle to get in the police car, which clearly George Floyd did not want to be in that police car. It is said he said that he was claustrophobic and he fought. That's where he's resisting, is to get out of that car. He doesn't want to be put there. And he immediately starts saying, I can't breathe. The first I can't breathe utterance of George Floyd is not when he is on the ground with Derek Chauvin's knee upon his shoulder and or neck. It is in the car at the original tussle. So those are all good points for the defense. Whether or not it creates a reasonable doubt in the mind of one juror, because that's all the defense is looking for in order to get a hung jury. So perhaps if there is a hung jury, they could persuade the government to enter into a plea bargain rather than try the case again. That what that is good cross-examination technique, because it's looking for doubt. Now, if you want to believe as a juror, Officer McKenzie, the female, that her medical opinion is correct, that doesn't mean that Derek Chauvin understood that someone who is talking may nonetheless be losing consciousness. The problem for Derek Chauvin is the obvious one, Vlad. Once he stopped talking and he stopped resisting, why did Derek Chauvin keep his weight on the body of George Floyd for such an extraordinarily long time? For heaven's sake, the paramedics had to get him off the body.
Well, so Rikki, the reason I highlighted what Eric Nelson said, the defense counsel, is because he sort of left that door open when he suggested that if a person stops talking or they pass out, then that would be another type of analysis, he called it. And if, you're the prosecutor and these are good prosecutors, these are good attorneys, well, I would then sort of wonder, okay, so did Derek Chauvin stop analyzing the situation? Did he just keep on keeping on with his knee on George Floyd's neck without analyzing the situation based on what Eric Nelson just said, which is if he said he couldn't breathe and he stopped talking or he passed out, well, that would require you to make another. What Nelson seems to be doing throughout this whole trial is talking about, the fluidity of situations that police officers find themselves in, giving these cops a lot of credit for the constant analysis that they make of the situation that they find themselves in. And that may be true in most instances, but what we see there, just based on what Nelson said, is that Chauvin stopped analyzing the situation. He had already decided that this was what he was going to do until the EMTs arrived, at least from somebody who's just observing and looking at the videotape.
Well, I assume that the tactic of Eric Nelson is to say that they had made, or Derek Chauvin had made, enough of a reassessment that they had then put in a second call to the EMTs for emergency medical assistance from the paramedics who eventually arrived. So perhaps what the defense is trying to say is, look, we reassessed, we realized that we had a bigger problem here than we thought, and so now we upped the code for the paramedics to arrive, and I was just holding him for the paramedics to come and give him first aid. The problem with that, of course, is the obvious one, which many witnesses have already testified to, is that the safety of the person that you are arresting is also your responsibility. And if someone becomes non-responsive, your job is to do CPR. I mean, I don't know how many more witnesses we need to be able to say that, you have 4 police officers there, not 1, 4, and you have 3 of them on the body in some form or other, and no one is coming to the aid of someone who is no longer responsive, who is laying on the ground, not for seconds. It's not like the paramedics arrived in 10 seconds or even 30 seconds. It's minutes upon minutes. So that's the problem for the defense in this case. And it's why when you get a standard, let's take the bottom one, when you get a standard like second-degree manslaughter that talks about this kind of conscious disregard, or you step it up to murder 3 of someone who really has a depraved heart or a depraved mind, those 2 charges are so close. And the problem for Chauvin is it took too long with no rendering of aid. I go back to the fact that almost every use of force case, which is found to be excessive or not excessive, we're usually dealing in seconds. I have no thought that I have ever seen or heard of a case where you have 9 minutes and 29 seconds of an encounter and minutes upon minutes of someone who's laying on the ground with 3 police officers who have some body weight at least upon him and who is non-responsive. I mean, he's not non-responsive for 9 minutes, but he's not non-responsive for 90 seconds either. It's much longer than that.
Right. And Attorney Nelson, at one point, and we were talking about this before the trial started, Rikki, I asked you about whether something is wrong. And as you pointed out to me, something could be wrong, something could be unethical, but it doesn't necessarily make it illegal. And Eric Nelson, during his cross-examination of Sergeant Stiger, talked about, I can't remember the name of the program that he had participated in LA, but it sort of rhymed with the word bad. But he said, at the end of it, he said, if something looks bad, it may be bad, but is it unlawful, is the question that Eric Nelson was posing. The question that I had in my head was, well, okay, maybe it's not unlawful, but what happens when what looks bad ends up in killing somebody?
Well, the phrase, Vlad, is lawful but awful.
Oh, right, lawful but awful, right.
In my career and in the career of those close to me, that has been an expression that I have heard for decades. And so there was a course about it, of lawful but awful. So something that looks awful often, I mean, really often, is quite lawful. I mean, there's nothing pretty about creating an arrest of someone who's resisting arrest. I mean, anyone. It's just not a pretty sight. But it may be all within policy, and it may, or it may be even a little bit out of policy, but it's still lawful. The problem here is not only does this look awful, but it is hard to believe by any standard that it could be lawful to be on someone's body, not only for in the length of the entire encounter, but to be on someone's body for minute after they are non-responsive and not to render aid. I understand all of the circumstances that Eric Nelson is doing his best, which he should be doing as a defense lawyer who is zealously representing a client, that he has to be picking away at all of the circumstances that would have gone into Derek Chauvin's decision, including what he heard from the dispatcher, including the fact that although this witness did not answer the question of whether or not, when he was shown the video, that George Floyd said, "I ate a lot of drugs," and that this witness, Jody Stiger, said that it was unintelligible to him. But the jury heard it, and the jury will continue to hear it. And when Eric Nelson translated it, "I ate a lot of drugs," to many, many people, that's exactly what it sounded like. And so that's another circumstance that goes into this. The crowd is another circumstance. The location. There's all kinds of issues that Eric Nelson is doing his best to show that Derek Chauvin's actions from the time he arrived were thoughtful in the minute or in the moment, because they're instinctive, of what to do in de-escalating or escalating force. The problem Eric Nelson has, and I repeat, is what does he do with all those minutes after George Floyd stops being responsive? And you can bet your bottom dollar that in redirect examination, that's exactly what we're going to hear. And from other witnesses, it's exactly what we're going to hear. Because as a lawyer, I've often said, you can make something look one way or the other when you're asking questions. But there are some facts that are what we call facts beyond change. That amount of time under 3 police officers' weight, whatever weight they were putting upon his leg, his back, or his shoulder, or his neck, while he was not responsive, is a fact beyond change.
All right. Rikki Klieman, as always, brilliant analysis. Thank you, my friend. Appreciate it.
Their voices grew loud.
Let's go back to the trial.